Okay. Good afternoon, ladies and gentlemen. It's fine day. Actually, we have feared if the typhoon devastated this area, but we were very lucky. We continue to review the rest of cases about a interstate commerce clause. You can find the case titled Philadelphia versus New Jersey, decided in 1978. You have a brief fact pattern about this case. New Jersey passed a law prohibiting importation into interstate of a solid or liquid waste in order to protect the public health, safety, and welfare from the consequences of excessive landfill development. Philadelphia was a plaintiff in this case, and other cities, as well as New Jersey landfill operators, challenged the law under the Commerce Clause. The New Jersey Supreme Court upheld the law and plaintiff appeals. Please see page 50 in the last printout. The issue of this case would be framed like this. May a state prohibit importation of environmentally destructive substances solely because of the source of origin? The court said no. And the lower court judgment was reversed in the Supreme Court. The court opinion was summarized as follows. First, this reason for passing the law may be legitimate, but the evils of protectionism can reside in the legislative means used as well as legislative and sought. This ultimate purpose may not be achieved by discriminating against out-of-state items solely because of their origin. This failed to show any other valid reason for its discrimination. And this statute requires out-of-state commercial interest to carry the burden of conserving this remaining landfill space in an attempt to isolate itself from a problem shared by all. Protection against such trade barriers serves the interest of all states and may even work to the advantage of a New Jersey in the future. Defendant claims this statute resembles quarantine laws, which are exceptions to these general rules. But quarantine laws merely prevent traffic in noxious articles regardless of their origin. It claims no harm from the very movement of waste in its borders and concedes that when the harm is felt, there is no basis to distinguish out-of-state waste from domestic waste. And we have a dissenting opinion from a Just Lankist and a Berger. This law essentially prohibits importation of items that could endanger its population and should be upheld. The court implies that the challenge laws must be invalidated because domestic waste may be used in the state's landfills. This fact ought not require it to exacerbate its problems by accepting out-of-state waste. So in Maine versus Taylor, the court held that a state could bar the importation of out-of-state bait fish where there was a legitimate environmental purpose that could not be adequately served through non-discriminatory means. You can see it is a tricky area between the state purpose and interstate commerce clause. And the next case involves the discriminatory effect of a state statute. Then we have some rules to counter this kind of statute. Let's see, we have a brief fact pattern here. An ordinance in Madison, Wisconsin prohibited the sale of pasteurized milk unless processed at an approved plant within a 5-mile radius of downtown Madison. And the sale, importation, receipt, or storage of milk for sale in Madison, unless originating at a farm inspected by Madison officials, who were also relieved from inspecting any farms further than 5 miles from city center. Dam milk was a plaintiff in this case. An interstate milk processor and dealer was denied a license to sell its products in Madison solely because Pete's plants were more than 5 miles away. Pete challenged the ordinance, but the state courts upheld it. Pete appeals. You might know the Wisconsin state is very famous for the milk production, and the nickname of this state titled a dairy state, and it is one of a major state industry. And the local ordinance attempted to regulate some of milk production in the context of interstate commerce. Therefore, it raised the interstate commerce clause issue of interstate commerce clause. Then we can ask, may a local statute having a valid purpose but discriminating against interstate commerce be upheld if there are non-discriminatory yet effective alternatives? The Supreme Court adjudicated negatively, a judgment vacated, and the case was remanded to the lower court. The court opined no federal legislation pertains to the issue, nor does the contend that Congress has authorized the regulation. But the enactment does clearly have a valid purpose and is thus within the scope of a local power to regulate. However, the effect of the regulation is discrimination against interstate commerce, which contravenes the Commerce Clause. Local statute cannot erect such barriers to interstate commerce, even to further varied health and welfare objectives, if reasonable non-discriminatory alternatives are available to protect these local interests. So, in the court position, this phrase is very significant to decide the case whether reasonable non-discriminatory alternatives are available. The record disclosed at least two such alternatives that afforded the legitimate local interest in health and safety. The court saw a U.S. Public Health Service inspections or out-of-town ratings and inspections could be a good policy for the substitute of the measure adopted by a local authority. And the court orders permitting it to enforce non-essential and discriminatory regulation would invite a multiplication of a preferential trade areas destructive of the very purpose of the Commerce Clause. That will be the majority opinion of the court. And we have dissenting opinion from Justice Black, Douglas, and Menton. There is no showing that P was unable to process its milk within the 5-mile radius. Local determination of the best method of sanitary control should not be overruled by the court. To do so elevates the rights to traffic in commerce for profit above the power of the people to guard the purity of the daily diet of milk. Then, what can you see the court opinion in its essence through the areas of this law? The court relied in part on a Minnesota versus Barber, decided 1898. In that case, Minnesota had prohibited the sale of meat that had not been inspected by a local official within 24 hours of slaughtering. The law necessarily discriminated against meat shipped from other states, and if copied by other states, would have destroyed commerce among the states. The printout came from a legal outlines about the United States Constitution law, which is adaptable to the Professor Kunda. Professor Kunda is a leading authority on the United States Constitutional law. And also a very great researcher, according to the recent survey of a citation studies. His article is praised a top in terms of impact of legal research conducted by Yale Law School. And around the Interstate Commerce Clause, we have some of the cases dealing with availability of less burdensome alternatives. The first of which is Hunt versus Washington State Apple Advertising Commission, which decided 1977. And let's see the fact pattern in this case. It is a brief, of course. A North Carolina statute required that all closed containers of apples sold, offered for sale, or shipped into state bear no grade other than the applicable United States grade or standard. And a related regulation required the USDA grade or none at all. The statute was intended to eliminate confusion resulting from a multiplicity of inconsistent state grades. The Washington State Apple Advertising Commission was a plaintiff in this case. Brought an action against him, was a defendant in this case, a state official, challenging the statute as unconstitutionally discriminating against interstate commerce. He had developed this own grades, widely recognized as superior to the USDA grades. USD means United States Department of Agriculture. It is initials of the department, and on which the reputation of its apples depended. The district court invalidated the statute, and defendant appeals. We have an issue in this language. May a local statute, which has a varied, a good faith purpose, but burdens interstate commerce, be upheld if there are reasonable, effective, non-discriminatory alternatives? The court said no, and the lower court judgment was affirmed. The court continued, when discrimination against interstate commerce is shown, the burden falls on the state to justify its regulation, both in terms of the local benefits following from the statute and the unavailability of a non-discriminatory alternatives to accomplish the same objectives. This statute is clearly discriminatory, as it covers only closed containers of apples, the very means by which apples are transported in commerce. The record also discloses the feasible, effective, and less discriminatory alternatives are available. Defendant recognized that the statute burdens the interstate sale of Washington apples, but claims that the burden is outweighed by the local benefits of protection of the public from fraud and deception. In reality, the statute does little to further this goal, at least with respect to peach apples. It permits undertaking under no grades at all. It directs its primary efforts at wholesalers and brokers rather than the consuming public. And since peach grades are in all cases equal or superior to USDA grades, they could only deceive or confuse a consumer to his benefit. In light of the statute, ineffectiveness and the existence of the reasonable regulatory alternatives, the statute is invalid. The preceding cases are often cited in other commerce clause cases. The Philadelphia case makes clear the facial discrimination is unconstitutional. And Denmark and Hunt show that if a regulation has a discriminatory effect, it is normally invalid. The court avoids analysis of the motivation for such statutes, but when a discriminatory effect is shown, it may examine at some length whether reasonable non-discriminatory alternative means are available for accomplishing the state objective. And later, we can see an example chart to summarize this position through a various cases. And you can see in the slides an example chart mentioning hierarchy of a United States law. For the summary of a previous discussion, I prepared an example chart to show you the hierarchy of U.S. law. As I mentioned, the United States is the pioneering state to frame the constitutional law as the supreme law of land. The vision was supported ideologically and in legal theory by 17th British jurist Koch and later by Sir Blackstone. They are champions of high law concepts to protect the common law against an abusive king's dictatorship. Their idea was a major influence in the newborn constitutional framework in combination with the separation of powers doctrine. And the United States actually adopted the tripartite government scheme in its U.S. Constitution. The constitutional hierarchy was confirmed as case law in Marbury versus Madison. Therefore, you can find the U.S. Constitution at the top, which prevails over other sources of law. It prevails over treaties and federal states, federal statutes. And if a conflict between these two, last-in-time rule applies. The subject created later in time would prevail over the previous cases of enactment, which means the later treaty would prevail over the federal statute of United States Congress, which was enacted prior in time. And we can find a executive agreement, which is federal in its nature, but could be subject to an official treaty or convention, which normally requires the approval of Senate. This would be a concise form of an international compact. So when the norms conflict with each other, the official treaty would prevail over executive agreements. Also, as connected with dual sovereignty between state and federal government, the federal law, including any layer of norms, should prevail over the state laws. This is even true against the highest state laws. The presidential order would prevail over the state constitution, for example. And the treaties have to be considered as one of federal laws by operation of the Federal Supremacy Clause. It was specifically pronounced in the provision of the United States Constitution. But you should bear in mind that the scope of federal legislation is specifically enumerated in its nature, which means a derivative power is theoretically narrower than that of state government. But the tendency on historical perspective have gone in reversed way to practically and interpretively expand the scope of federal power. And in this context, the Supreme Court of the United States has long played a very important role to address this kind of questions. One other interesting point would be a practice of international treaty in the United States. The treaty is not a law in itself, meaning all treaties are practically and theoretically considered non-executing nature. The court wouldn't take a hard way to render recognition of self-executing treaty, to say The treaty language may be detailed to apply or explicit in its provision to authorize its executing status, blah, blah, blah. So it is one of a task to identify if the treaty at the bar would be a self-executing or should be excluded from the doctrine on presumption of a non-self-executing status. And this attitude about a treaty in the United States a federal court and other governmental branches may occasionally bring a conflicting aspect with international cooperation. As one of global states, the United States may face some of criticism through the state of treaty negotiation and its domestic effect. It is an intricate and tricky area of law, and may evoke some of exotic occasion against the foreign observers. For instance, we can recall two typical cases involving the International Criminal Tribunal and Tokyo Environmental Protocol. I have not been skillful through the whole of this slide. This example chart is a little inferior to the former one, but you can read them. This chart summarizes the essence of the core rules about the interstate commerce clause. When we deal with the cases involving interstate commerce clause, the first question should be addressed like this: does the state regulation affect an activity addressed by federal legislation? Let's have an answer about this question. If we can answer yes, then the state statute may be invalid, or other local ordinance. If federal law preempts the field or the state law conflicts with the federal law, the preemption doctrine established by the court about the Supreme Clause may operate in this case. There would be a field preemption or other theories. Therefore, those would apply properly to settle the case. And in our other case, the state statute or local ordinance may be varied if the federal law authorizes the state law. It would be straightforward if the federal law authorizes the kind of a state regulation. If you have to say no to the first question, then we have to reframe the question to think about. Does the state regulation discriminate against interstate commerce? If we say yes, then the state regulation may be invalid unless it furthers an important non-economic state interest and there are no reasonable non-discriminatory alternatives. Over the many cases, non-economic interest would be less weighty than other a kind of a interest involving a humanitarian interest or other a critical public interest. Or the state is acting as a market participant. In this case, the state is no longer a sovereign entity. They are virtually analogous to other private entities engaging in commercial activity. This kind of logic would also apply to the international context involving a dovetail laws or other international laws. If we say no against the second question, then we have to face this third type of question to think about the issue of interstate commerce. Let's see, does the state regulation burden interstate commerce? We may say yes, or we can say no. If you say yes, then the state regulation may be invalid unless the state's interest in the regulation outweighs the burden on interstate commerce. If you answer no, then it will be a valid state regulation. Now we turn to the issue involving a substantive due process. You can find the introduction on page 96 in the last printout. As the Perko and Adamson cases illustrate, the court can use due process clause as a basis for articulating fundamental rights. Those cases involve a procedural fundamentals in an attempt to ensure fair trial. However, the court has also used the due process clause to protect substantive rights. Beginning with Lockton versus New York, the court invoked due process to protect economic and property rights. In more recent times, substantive due process has not been used to protect economic rights, but instead has been invoked as a basis for protecting privacy and personal autonomy. The basic issue underlying the substantive due process cases is whether the court may properly protect rights not specifically mentioned by the Constitution, simply by declaring them fundamental rights. You know that we have a Bill of Rights throughout the first part of 10 amendments in the United States Constitution. And we have also captured a provision about a fundamental rights. And it is a little gray area about a specific items of fundamental rights when we interpret the United States Constitution. And the court have long relied on the theory of substantive due process when the court faces the issues of a new raised economic policy or a private issue. It is notorious with the abortion case throughout the recent period of time. And the birth of a substantive due process issue involving economic regulation might well start with the Rockland versus New York, decided 1905. Before we talk about the Rockland case, we briefly review the background about economic regulation in the United States. Although the Code did not expressly recognize substantive due process as protecting fundamental economic rights until Orgay versus Louisiana decided 1897, arguments about the validity of a governmental interference with personal liberty and property had long existed. In Carter versus Burr, which was the case in 1798, Justice Chase argued the government existed to protect personal liberty and private property, which could be considered as a very traditional law of a liberalistic government. We properly call it a limited government framework. An act by the legislature removing the protection would necessarily exceed the legislative authority. In the same case, Justice Ruddell argued the constitutions were intended to limit the legislative power. It is the document to regulate the legislative power. The court may believe a statute violated natural law, but could not declare it void unless it was prohibited by the Constitution. In Moon versus Illinois, decided 1877, the court differed to a legislative judgment in rejecting an attack on a state law regulating grain elevators, while suggesting the potential limits on legislative power. In that case, the court refused to scrutinize the reasonableness of the rates levied against business owners with a near monopoly on grain storage, because under the police power, the state could regulate industrial use of property for the public good. Yet the court noted that the reasonableness of merely private contracts must be ascertained judicially. Later in Mergler versus Kansas, which is a case of 1887, although the court sustained a law prohibiting intoxicating beverages, it announced they ought to examine the substantive reasonableness of state legislation. In Orgay, a state law prohibited the insuring of Louisiana property by any company not licensed to do business in Louisiana. Orgay had insured his property with a New York insurer and was convicted of the offense. The court held that the statute derived Orgay of his liberty to contract without due process of law. And the leading case around this area would be Lochner versus New York. In this case, Lochner, who was a defendant, was convicted of permitting a bakery employee to work for him more than the statutory a maximum of 60 hours per week. He challenges the law as a violation of the liberty to contract protected by the 14th Amendment. The issue of this case would be framed in this way. May a state generally prohibit private agreements to work more than a specified number of hours? Around this time, it was inconceivable for a government to intervene the dimension of personal liberty to contract. And the court went in that way. The court held no, and the local judgment was reversed. The general right to contract in business is clearly part of the individual liberty protected by the 14th Amendment. However, the right to hold both property and liberty are subject to such reasonable conditions as may be imposed by a government pursuant to its police powers. An earlier law restricting the work hours in certain dangerous occupations was upheld. The law here challenged, however, has no reference whatever to the health, safety, morals, nor welfare of the public. The state claims an interest in the individual worker's health, but this goes too far. The individual's liberty must impose some restraint on the police power. This is not a substitution of the court judgment for the legislature, but merely a determination of whether the attempted regulation is within the state's police power. We have a set of dissenting opinions from Justice Harlan, White, and also we have a dissenting opinion from Justice Holmes. As you know, Justice Holmes is normally referred as a great dissenter in the history of the United States Supreme Court. Let's see. The liberty of contract is subject to reasonable police regulations. The court ought take judicial notice of the injurious working conditions in bakeries. These conditions provide a reasonable justification for the state legislation. Many comparably restrictive uses of the police power have been upheld by the court. The Constitution was not intended to embody a particular economic view, but was framed to permit expression of dominant opinions. In other words, the laws fully reflect the people's choices, though it's not clearly unrelated to a public health and ought to be upheld. Therefore, we have some result about this area of law according to the court opinions through the various cases. The Supreme Court viewed a three set of criteria to contest the raised issue in this area of law. First, the court examined ends of ends or purposes, and the code put an emphasis on its means. And the code also considered seriously the effect of the regulation. Therefore, you must examine the purpose of the legislation. That is, the object. Is the object legitimate, appropriate, or necessary? That will be a critical question when you think about this issue. Does the law promote in some way the health, safety, welfare, or morals of the people? This is answered from the language of the statute, the legislative record, and the history behind the passage of the statute. And it's a question of law for the court. Then you have to be further on its means. Are the means used to accomplish the legislation purpose reasonable and appropriate? That is there a real and substantial relationship between the means used and the legitimate end? And the last question would be about its effect. What is the effect of law on the liberty of the parties involved, on the property, and on their lives? If the effect is too drastic, the law might violate due process. Around this time, there will have been plenty of a public regulation surrounding a maximum hours of labor and yellow dog contracts, or minimum wages, and business entry and economic regulations, and etc. As I said, it is one of a critical periods for a transition of a ideology. And we have to stop now. The time was closed.